Hello, my name is Jim Kovaleski. I'm one of the attorneys at O'Donnell Weiss Matei. I'm joined by Thomas McCabe, Tip McCabe, one of our other attorneys. We have offices in both Pottstown and Phoenixville. This evening, Tip is going to be talking about DUIs and the amended Interlock Act, which doesn't mean a whole heck of a lot to me. Hopefully, it will mean something to you guys in a couple minutes after Tip walks us through it. So, Tip, why don't we start off with what's a DUI? We'll start off very basic.
Sure. A DUI it stands for driving under the influence of either alcohol or a controlled substance. A controlled substance being some type of narcotic or unprescribed medication such as Xanax or things of the like. And in Pennsylvania, kind of goes without saying, you cannot be operating a motor vehicle when you're under the influence of alcohol or a controlled substance. That is a crime. For many, many years, if you were charged with a DUI or driving under the influence, there were only some limited options, assuming that the Commonwealth, the prosecutor's office, were able to prove you guilty. And the biggest hardship beyond any potential jail time, and it's hard to imagine something that would be more of a hardship than jail time, is the loss of license that comes along with a DUI conviction. And for many years, first-time DUI offenders were faced with the prospect of up to potentially 1 year license suspension and very little recourse that they could do with that, regardless of how that might affect their job, family, medical situations that they might have, and so forth. I think in what the Pennsylvania legislature has done with that, and recognizing that not everyone in Pennsylvania lives near reliable public transportation or even Uber or Lyft or other taxi services, has modified or amended what's called their Ignition Interlock law.
So, amended the Ignition Interlock law. What's an Ignition Interlock?
Well, an Ignition Interlock is a device that is placed inside your vehicle that you breathe into. Think of it almost like a breathalyzer, if you will. This device kind of overrides your ignition, your key or start press, so that if the device detects any alcohol in your breath, the car will not start. So under the prior law, before the amendment, this device was only mandated for second and third offense DUI offenders. Now the option to have an Ignition Interlock is provided for first-time offenders. And you might be asking, why would I want an Ignition Interlock? Well, with that comes the ability to have a limited license designation provided to you by PennDOT. You'd have to pay PennDOT's requisite fees, but allowing you to still operate your motor vehicle that you register with PennDOT with an Ignition Interlock device in that vehicle, and that would allow you to still drive to work, to medical appointments, lawyers' appointments, so on and so forth, while serving your suspension. And it's the legislature, I think very wisely, trying to balance people's ability to still earn a livelihood, but at the same time trying to protect society from people driving a car under the influence of alcohol. So again, the device itself, if you breathe into it and there's alcohol in your system, the car will not start. In addition, while you're driving, it does randomly the device will randomly ask the driver to still breathe into it. Now, if it detects alcohol, it doesn't just seize the car up and stop it, but it does send information back to the provider of the Ignition Interlock that alcohol was detected while the vehicle was driving, and that would be a violation. Now, these devices are not free. They are rented at registered and licensed providers. But again, what this does is allow for the first time for first-time offenders immediate availability to apply for and have an Ignition Interlock device. There might be some delay between when a conviction or a guilty plea occurs and the installation of the device and the license, the limited license being received, but it's certainly a lot quicker and certainly a lot less onerous than looking at a potential 12-month license suspension.
Sure. It sounds like, I think you mentioned it a moment ago, it's the legislature, using your words, balancing the need to protect citizens against individuals driving under the influence, but also understanding that people make mistakes and allowing them to serve their suspension while still having limited access to their vehicles so that they can get to work, still be a productive member of society.
Exactly.
Which is great. So how does this affect, and why don't you tell us a little bit about this program as well, how does this affect ARD applicants?
Sure. ARD is what's considered a diversionary program. ARD stands for Accelerated Rehabilitative Disposition. It's a mouthful, which is why everybody usually shortens it to ARD. It is provided county by county, and it is a program for first-time offenders, usually low-level crimes of nonviolence, and for individuals who don't have any priors in their background. A lot of times it is people who are facing first-time driving under the influence charges that apply and qualify for ARD. With ARD, depending on what was in the person's system, either how much alcohol or a combination of alcohol or drugs, determines what license suspension you face under ARD, and that's usually between 1 to 2 months of a suspension, 30 to 60 days. So the question was, under this new amended law, can you get an ignition interlock for that 1 to 2 month period? Unfortunately, no. The ignition interlock law does not affect your 1 to 2 month ARD suspension. So the choice and what you would want to discuss with your attorney is, does the impact on your life getting into an ARD program, and the benefit of ARD is that if you complete the program, all the charges against you get dismissed, and you have the option to then expunge your record. Expunge meaning have your record destroyed by any state agency that had records of you being charged with this crime. So you would want to talk to an attorney to balance out what was least impactful on your life. Having a DUI conviction on your record for effectively life, but being able to get an ignition interlock immediately versus suffering a 1 to 2 month license suspension, serving no jail time under ARD, and then having all your charges dismissed and the ability to have your record expunged. Those types of decisions really should be made in consultation with an attorney who practices in the area of criminal law, criminal defense, something that we do here at O'Donnell, Weiss & Mattei, and that you would want to speak to someone in that field.
I think you're right. I think a lot of people have the misconception or the notion that ARD is only for DUIs. So it goes beyond that. There are different instances where that can be applied, but it is very often where you see it with DUIs. So I guess I understand that connection. If you're in the ARD program, is there any way to get a work release license or any type of work license, or is that off the table as well?
That is generally off the table as well. Under the laws, the OLL operator limited license generally is not available until you've served at least 60 days of a license suspension. Okay. So with ARD, the benefit is your charges get dismissed. You can expunge your record at the end of successfully completing the program. The disadvantage is you're going to be suffering a 1 to 2 month license suspension and probably relying on the kindness of family and friends to get you around until that is done. Because the one thing you do not want to do is drive while your license is suspended related to a DUI. Because if you're caught driving, you're going to face what's called a 1543B, or driving under suspension DUI related. And even if you have nothing in your system, meaning alcohol or drugs, you're going to be looking at a mandatory minimum 60 days of jail. So this is why it's very important to talk to an attorney, such as the attorneys here at OWM Law, who practice in the area of criminal defense and can assist you with your needs when you're facing the stressful situation of criminal charges, specifically DUI.
Good point. There's a lot to consider, so make sure you're getting some advice as to all those factors, and reaching out to an attorney is never a bad thing in those situations. So again, my name is Jim Kovaleski. I was joined by Tip McCabe. We are attorneys with O'Donnell, Weiss & Mattei, which has law offices in both Phoenixville and Pottstown. Take care. Thank you.
Thank you.